You're thinking about getting a will, and you probably should have one. It's something all Canadians should have. But you're thinking of getting a will and you're not sure what are the things you have to think about. Now, first of all, don't panic. We're going to go through a list of things you have to think about, but your wills and estates lawyer should sit down with you and review everything when you're starting to make decisions. But in the back of your mind, you should think about some of the broader things. Just don't get hung down with it. Sometimes people get stuck in a position where they can't decide, what one thing will be in their will, and they just take no action and don't get one. That's usually the most serious situation, because if something happens to you, your family's left without the will that's there to protect you, them, your wishes, the assets, and everything. So we're just going to go through them, but don't stress. Your lawyer, your wills and estates lawyer, will help you through it. So first, think about who you want to carry out your instructions. Now, this person is now called the personal representative. They were formerly referred to as the executor or the executrix, but this is the person who's going to make sure that your wishes are taken care of. You decide who it is that makes takes those actions for you. It has to be somebody that you trust and know well enough that you can put faith that they will follow your wishes and not do anything untoward with your estate. Next, you want to think about who's going to be the guardian of your children. And I've had couples struggle with this, where if they don't have someone that they trust with their kids, they just don't get any of a will package done, struggling with it. What I usually say to them is like, you know what, if you change your mind on this one 2-3 times, we'll just reprint it with the new name, we won't charge you, just to take the pressure off, and there usually takes things and makes it easier for them. But you have to decide who will raise your children if something happens to you in a way that's consistent with how you want your children to be raised. So this is called the guardian, and they're going to step in to be a parent in your absence if something happens. 3, you need to set up a trust. Not always, but if you have any minor beneficiaries, what a trust does is it holds those funds for them and distributes it a little bit at a time. While they're growing up, it'll pay for school or some living expenses. You can say that at the age of 18, they get 10% of what's left, maybe at 20, a certain percentage, 30, a certain percentage. You could spread it out. Also, if you're giving money to a person who's just not good with money, you could set it up in a trust that protects them and the money from just being blown crazily. In reality, most 18-year-olds who get a pile of money aren't that great at investing it. Next, you have to think about, are there specific gifts that you want to give everybody? Now, this could be family heirlooms or jewelry. I've had a client that gave an old tractor that was in the family for generations to somebody along with money to restore it. Think about the things that you want a specific item to go to a specific person. Those are specific bequests versus a residue of your estate, and you want to make sure that you've thought it through, and again, we can help you with the process there. Now, also, you will have to contemplate real estate when it comes to your will, because those are assets that, they are no different than other assets, but they're worth more. So, for instance, if you are giving a house to one person and X number of dollars to another and X number of dollars to another, that house might appreciate more than the dollars, so it may not be fair. Also, you have to think about how you hold your real estate. If you hold it as a joint tenant, then when you pass away, your surviving joint tenant or tenants gets all of the property, and it never hits your estate, so none of your beneficiaries get it. If you are in a blended marriage, a second marriage where you both have your own kids and want your own kids to get part of your home, then we recommend putting it as tenants in common so that your share of the house is distributed per the estate. You can still let the person stay there. They can still live there. You can give them a life interest, but the value of the assets then there for them. Also, with real estate, you have to know that we need to get probate. That process is a lot faster than it used to be, so you don't have a lot to worry about. Next, you want to think about things like life insurance or registered investments or GICs or TFSAs. These financial products can allow you to name a beneficiary outside of your estate also, so that on your passing, it bypasses the will, and that money goes right to the person that you want it to. You can also choose to not name a beneficiary there. It goes into your estate and it's distributed with everything else for your estate. Number 7, and sorry I haven't been numbering these, is compensation for your executor and your trustee. You can set it out, but an executor sometimes has a lot of work to do, and you might want to think about compensation for them, whether it's a percentage of the estate or a flat amount of dollars. You want to think about that kind of thing in advance so the person's not just frustrated that they're doing all this work and not really seeing a benefit from it for themselves. Next, sometimes you're going to have to get a bond. So if your executor is someone who's not resident in Alberta, the courts will often make them get a bond, which is essentially insurance to make sure that the person doesn't leave the province with the money and then Alberta court system can't rule over them. Then it becomes another issue. So you want to think about that in terms of who you're picking, but also that might be a requirement. Next, you want to think about the signing requirements of your will. So if you're doing your will separately from a lawyer, you have to remember you need 2 witnesses who are watching you sign at the same time, and one of those witnesses is going to have to be swear an affidavit that they saw you sign. These are technicalities that can invalidate a will and then leave your estate in an estate, which means it's no different than if you died without a will. Next, 2 more things, and these are the last 2, is we want to look at the personal directive and a power of attorney. So one, a power of attorney is a document that lets somebody sign documents for you. You could set it up where they could do it at any time, or one that only jumps into use if you lose capacity. Typically what we do is we set something up that they have to get a doctor's signature to say you don't have capacity, and at that point they can start making decisions for you. Now this only has to do with your assets, your house, the dollars and things like that, not your person. That document is called a living will or a personal directive. And a living will is a document that gives someone permission to make medical choices for you. So this is not just the crass pull the plug or not, but what kind of facility you live in if you can't make decisions for yourself, what kind of social activities you take part in, religious activities. It's your life and you as a person, how it's being dealt with. Those could be the same person as the power of attorney, or it can be a different one. So these are the kind of things that you want to make sure you pay attention to so that your estate is set up not just for you, since you'll be passed, but for your wishes and also for your heirs, because it makes life a lot easier for them, and that's what you want to leave them with a memory of, not a headache.